Birthright Citizenship. Again. Welcome to Law and Society. Please subscribe. Today I'm going to talk to you and give you a summary of the Birthright Citizenship ruling by the Ninth Circuit Court of Appeals. It's the appellate court that oversees California, and the suit is brought by the states of Washington, Arizona, Illinois, and Oregon, and individuals who are expectant mothers. Well, we're going to see later on that the court only assumes jurisdiction over the state plaintiffs and not the individual plaintiffs. And this episode may go a little long because I want to address everything that the Ninth Circuit has addressed because they have gone into the merits. Mind you, and we're going to hear in this case as well, references to the class action certification that happened in New Hampshire. And that's partially the reason why the individual plaintiffs in this case, their claims were dismissed. So, the states of Washington, Arizona, Illinois, and Oregon, along with these individual plaintiffs, challenge as unconstitutional Donald Trump's executive order number 14160, which purports to deny citizenship to the children born in United States territory of parents temporarily or unlawfully present in the United States. So they lost, the government lost in the district court level. The district court imposed an injunction and enjoined this executive order from being enforced. Defendant government appeals, contending that the states lack standing to challenge the executive order, that it was error to issue a preliminary injunction, and that the scope of the injunction is overbroad. We address whether the executive order is constitutional and valid. We conclude that the executive order is invalid because it contradicts the plain language of the 14th Amendment's grant of citizenship to all persons born in the United States and subject to the jurisdiction thereof. So here is essentially what the elevator speech version of the case would be. The government goes against the plain language of the 14th Amendment. Then the court goes into how that is, and there are many factual and procedural issues and legal issues like standing and mootness that the court addresses as we keep going. Because individual plaintiffs are covered by a certified class in another federal court, which is the New Hampshire court, we decline to exercise jurisdiction over their claims and dismiss them. State plaintiffs have standing, are likely to succeed in demonstrating that the executive order is unconstitutional, and therefore we grant preliminary injunction and the necessity of it being a universal preliminary injunction to give states complete relief, which is different from the ruling that the Supreme Court gave out that said individual cases, one district cannot apply their ruling to nationwide universal rulings, despite the fact that it's a constitutional violation. So here you see that the Ninth Circuit, is taking the way of saying that we are looking at the states as the plaintiffs in this case. The case for expectant mothers who fall into that putative class is already a certified class in New Hampshire, so we're not going to uh, interfere in that case, and the plaintiffs in this case actually are plaintiffs, class plaintiffs in that putative class if they fall into the categories that are the same categories as presented in this case. So the 14th Amendment was adopted after the Civil War, rejected the holding of Dred Scott, and put citizenship beyond any governmental unit to destroy. And then there's the whole explanation of the United States versus Wong Kim Ark in 1898, at a time when the Chinese were not permitted to become citizens of the United States because of the Chinese Exclusion Act. With the backdrop of that sort of antagonistic environment, social environment in the country, the Supreme Court considered the case of Wong Kim Ark, a Chinese American man who was denied re-entry to the United States despite being born in the United States. The Supreme Court held that the Citizenship Clause stands for the fundamental rule of citizenship by birth within the dominion of the United States, notwithstanding alienage of the parents. Although Kim Ark's parents would have been unable to naturalize or even return to the United States, Kim Ark acquired United States citizenship by birth within the United States. So the judiciary, Congress, and the executive branch have consistently and uniformly protected the Citizenship Clause's explicit guarantee of birthright citizenship regardless of the immigration status of an individual's parents. The executive order at issue states in relevant part that the privilege of the United States citizenship doesn't automatically extend to persons born in the United States. Section 1 of the executive order says. Section 2 states that it is a policy of the United States that no federal agency shall issue documents recognizing such persons as citizens or accept documents by state governments recognizing such persons as citizens who are born 30 days from this executive order. And Section 3 mandates that officials cannot act or forbear from acting in a manner inconsistent with the executive order. So essentially telling everybody to go against the Constitution. So the states filed a complaint after the executive order was issued and moved for a temporary restraining order. The district court granted the district order, and after that, individual plaintiffs filed for a putative class action. The district court consolidated the cases and filed a consolidated complaint. Each group plaintiffs have moved for preliminary injunction. So we see the procedure here has happened in a way as to not to create a class, because states can be part of a class action. It has to be individuals only. And remember that certified class has already been certified in New Hampshire. The order goes on. On February 6th, the district court granted preliminary injunction enjoining the defendants from enforcing the executive order. The district court concluded that the balance of equities and public interest strongly weighed in favor of entering the preliminary injunction. Also concluded that there was going to be irreparable harm and that the plaintiffs were likely to succeed on the merits. The district court granted this while after the district court granted these injunctions, other courts throughout the country also implemented injunctions enjoining the executive order. The Supreme Court accepted review on the scope of the injunction. So we're talking about another case that held that the universal scope of the injunction was impermissible insofar as it was based on individual and associated plaintiff standing, leaving open. So we're talking here about the ruling of United States versus Trump v. Casa, where they said that you cannot have universal injunctions with individual plaintiffs, leaving open the question whether universal injunction may be justified in order to give complete relief to appellee states. So here it's about states. And so the District of New Hampshire has since provisionally certified a nationwide class of plaintiffs and issued a class-wide preliminary injunction. And, you hear that more than once. And then the court goes into the issue of standing and asserts standing must be met by persons seeking appellate review, just as it might be met by persons appearing in courts in the first instance. All that is needed to entertain an appeal on issue, however, is one party has standing. So plaintiff has standing if plaintiff can show an injury in fact that is concrete and particularized and actual or imminent, not hypothetical, that the injury is fairly traceable to the challenge action of the defendant, that it is likely, as opposed to merely speculative, that the injury will be redressed by the favorable decision. Under this general rule, standing requires a showing of injury, causation, and redressability. Talking about the state plaintiffs here, state has standing to bring suit where the federal government's action directly reduces the number of individuals that a state entity serves, causing loss of revenue that the state would have otherwise received under existing federal contracts. So that's the economic argument. And we hear later on that although your economic harm may not be a sole reason in this instance, because there's no other redressability possible because the defendant is the government, that this equitable relief is warranted. So states have presented evidence that more than 1,100 infants born each month in the plaintiff states would be subject to the executive order. States accordingly allege that they will lose millions of dollars of contracted reimbursements that they would otherwise receive. It talks about the economic harm caused to the state plaintiffs when, if they are to follow the illegal, unconstitutional order. So you have to show the harm that is being caused, and in order to have the standing. And so here's what the states are asserting. And the Ninth Circuit concludes that the states have shown that loss of reimbursement fundings and additional expenses incurred by the development of a new system to determine eligibility are concrete and imminent injuries, in fact, traceable to the executive order and redressable by an injunction. So defendants suggest that economic losses would be self-inflicted because states need not provide social services unless they choose. However, it is not a voluntary choice by the states for the federal government to stop paying for these services or to assume the costs that follow. Although the executive order does not on its face impose a duty on the states to change their methods of determining federal eligibility, the states would nonetheless be required to make these changes to comply with other federal laws. So, you see that the state is asserting standing because of its harm and the injury being caused, and that's why the state plaintiffs have standing in this case. The court says we decline to exercise jurisdiction with respect to the independent individual plaintiffs and agrees with the district court that the denial of citizenship is a concrete and imminent injury, in fact, traceable to the executive order and redressable by an injunction. However, one of the individual plaintiffs have since given birth, and then the other one is about to give birth. So he talks about the mootness of the individual plaintiffs because their child has been born and is a citizen of the United States, and therefore their claim is now moot. But because the district court below does not certify the class, there remains a question as to whether individual plaintiffs' claims are moot or whether an exception of mootness applies. We decline to address that question because we determined that to the extent the individual plaintiffs have live claims, those claims are covered by this class action certified by the District Court of New Hampshire in Barbara et al. That's the case in New Hampshire. And dismissal of the individual plaintiffs is proper on those grounds. A court may choose not to exercise its jurisdiction when another court having jurisdiction over the same matter has entertained it and can achieve the same result. So you see here the appellate court holding back its discretion and saying, no, we're not going to rule on the individual plaintiffs here because the individual plaintiffs' claims here are the same that are being advocated in New Hampshire in a case where a court has already certified a class of people who fall into the category of these individual plaintiffs in this case. On the issue of preliminary injunction, now the court says that the winter test requires that the party seeking the injunction is likely to succeed on the merits, that it is likely to suffer an irreparable harm in the absence of preliminary relief, the absence of, number three, the balance of equities tips in its favor, and that an injunction is in the public interest. And we'll see that the court essentially says the most important is winning on the likelihood of success on the merits. Everything, the other factors sort of merge with that in a case where the state is the plaintiff, where a state is the plaintiff. So we first address whether the executive order violates the citizenship clause. The parties dispute the meaning of the subject to the jurisdiction thereof. And so I've talked about this before, and this has been the issue that Donald Trump has brought up as the crux of his, really weak argument that all persons, the 14th Amendment Citizenship Clause says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states in which they reside. And so there's dispute is on subject to the jurisdiction thereof. Plaintiffs contend that the phrase subject to the jurisdiction thereof means subject to United States authority and laws. Because the executive order attempts to exempt from citizenship persons who are both born in the United States and subject to the United States authority, plaintiffs contend that it violates the Citizenship Clause. Defendants say that they first contend that jurisdiction does not refer to regulatory jurisdiction, jurisdiction as defined by government's authority of lawmaking, but instead political jurisdiction, which is rooted in allegiance, and protection. None of that is stated anywhere in the 14th Amendment. And the court makes it clear that it's not mentioned that there has to be an allegiance and protection requirement. They then contend that the person only owes such allegiance to the country in which the person is permanently domiciled, and the domicile of the child follows the domicile of the parent. Individual present temporarily or unlawfully in the United States cannot establish permanent domicile. Their children born on United States soil do not owe allegiance to the United States and are not subject to its political jurisdiction. So this is all cockamamie that they're coming up with without any sort of case precedent for it. The court goes into the ordinary meaning. We conclude that the text of the 14th Amendment support the plaintiff's interpretation. In interpreting the text of the Constitution, courts are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning. Jurisdiction was commonly used in reference to power of the courts, defined as legal power or authority of hearing and determining causes. But in reference to nations, jurisdiction was also defined as the power of governing or legislating, the right of making or enforcing laws, the power to write or exercising authority, and the limit within which power may be exercised or extent of power or authority. This ordinary meaning of jurisdiction is consistent with plaintiff's interpretation of subject to the jurisdiction thereof, as subject to the laws and authority of the United States. There's nothing contradictory that the defense provide in terms of the definition. They only argue that subject to the jurisdiction cannot simply refer to regulatory jurisdiction, because that definition would render the Citizenship Clause requirement as just jurisdiction surplusage. They claim that the United States has exclusive and absolute regulatory jurisdiction within its territory, so that all children born in the United States are subject to its jurisdiction. Supreme Court precedent makes clear that reading subject to the jurisdiction thereof means subject to United States authority and laws is not redundant. Wong Kim Ark directly addressed the meaning of the phrase subject to the jurisdiction thereof. The court stated that the real object of the dual requirements of birth in U.S. territory and being subject to the United States jurisdiction was to include, by the fewest and fittest words, the two classes of cases: children born to alien enemies and hostile occupations, and children of diplomatic representatives of foreign states, both of which have been recognized exceptions to the fundamental rule of citizenship by birth in the country. So, there are certain cases in which every sovereign is understood to waive the exercise of a part of or complete exclusive territorial jurisdiction. That's when a hostile power occupies the United States, sovereignty and over territory is suspended. In those instances, foreign ministers have immunity from U.S. jurisdiction, but none of those cases are important here. The court's primary concern was whether the subject to the laws and enforcement power of the United States. The Supreme Court, because in Wong Kim Ark reasoned the word subject to the jurisdiction thereof must be understood in the same sense in which the like words have been used by Chief Justice Marshall in the well-known cause of the exchange, the court must have understood the phrase to refer to the United States' ability to fully subject an individual to its laws. The court in Kim Ark also held clearly that the decision in Elk v. Wilkins concerned only members of Indian tribes. So here are the exceptions, and that the plaintiffs do not fall into, and the defendants do not contest on. But you're talking about what the 14th Amendment excludes, and it's not people who are born in the United States. In terms of Supreme Court precedent, defendants claim distinction between political jurisdiction and regulatory jurisdiction is not supported by precedent. Supreme Court and our court have used political jurisdiction to refer merely to the United States lawmaking authority. Second, the court did not hold or even hint that there was a requirement of preliminary allegiance or exclusive allegiance in either of the court's precedents. In Kim Ark, court repeatedly equated allegiance merely with obedience to the laws of the sovereign, saying that allegiance is nothing more than the tie or duty of obedience of a subject to the sovereign under whose protection he is. And then goes into the basis of this law, which is English common law, saying that you are a citizen where you are born. So, the text and ordinary meaning of the Citizenship Clause, as well as Supreme Court precedent interpreting the Citizenship Clause, support the plaintiff's interpretation that subject to the jurisdiction thereof means subject to the laws and authority of the United States. So then they go into permanent domicile. There's no permanent domicile requirement either. And there's no constitutional or statutory or Supreme Court precedent that backs up the defendant's assertion of, permanent domicile or faith and allegiance, owing allegiance. It talks about how it is as simple as you are born where you're born and you're the citizen there. Before the 14th Amendment, the prevailing view was that the United States adopted its idea of citizenship by birth within the territory. Enslaved individuals were often ignored by the common law analysis, and citizenship for free black people before the Civil War was disputed and often determined in part by state law. And then they defendants provide this Swiss jurist's view that, children of foreign permanent residents born within the territory are not full citizens. And that is completely counter to how American law has developed. The common law understanding of jurisdiction within the sovereign's territory and the recognized immunities from it are more consistent with plaintiff's interpretation of the Citizenship Clause. It goes into the drafting history of talking about what the subject of the jurisdiction meant. The public understanding was the examination of a variety of legal and other sources to determine the public understanding of a legal text in the period after its enactment or ratification is a critical tool of constitutional interpretation. The Supreme Court's interpretation of the Citizenship Clause in Wong Kim Ark supports plaintiff's interpretation because the Supreme Court there repeatedly equated jurisdiction with being subject to the laws of the United States. All private non-citizens are subject to the jurisdiction of the United States, while within its territory. So the question of the child being born in a certain place where there are laws that would cause harm to states if they were not enacted because they aren't counting the citizens properly, the executive order not only goes counter on its face with the 14th Amendment, but then it also goes against all of these laws that says that, you determine constitutionality based on the 14th Amendment, and then you follow out these procedures because they were born in the United States, and without that constitutional protection, it would cause states to lose money over, registering children who are being born in those states. Because the court in Wong Kim Ark stated that persons who are within the jurisdiction of a state for the purposes of the Equal Protection Clause must also be subject to the jurisdiction of the nation, all persons subject to the laws of states are subject to the jurisdiction of the United States. So the court extensively talks about how there is a lot of judicial precedent and there is immigration appeals where, there were kids who were taken by their parents to Poland. This child was at the age of 3, served in the Polish military, but was nonetheless considered a U.S. citizen because he was born in the United States before their parents moved. So there are many instances that the court provides and essentially supporting the plaintiff's claim of what subject to the jurisdiction thereof really means. Then the court goes into the constitutionality of the Immigration and Nationality Act and says that, Congress made clear when enacting this statute that it was borrowing the statutory language from the 14th Amendment. A statute adopting from another source generally conveys the original source's well-settled meaning. The statute's language is interpreted in accord with the ordinary public meaning in its terms at the time of its enactment. Meaning of the subject to the jurisdiction thereof has been settled by the Supreme Court and in public understanding at the time the statute was enacted. So the court concludes that the executive order also violates the Immigration and Nationality Act. So where there is irreparable harm in this case is that state plaintiffs are likely to suffer irreparable economic injury on the basis of being denied federal reimbursements for medical care and social services provided to children no longer considered citizens under the executive order. So the federal court said, the appellate court says that was the right decision by the district court. Plaintiff urges the theory of economic harm. It is not normally considered irreparable, but we have held that economic harm is irreparable when monetary damages are unavailable. Because plaintiffs are federal officials and agencies, money damages are unavailable in this case. So, because the denial of reimbursements and administrative costs are economic injuries for which monetary damages are not available, we conclude that state plaintiffs' injuries are irreparable. And then you go into the balance of equities and public interest, and the court says that when it comes to the government being a party to the suit, the final two factors merge. And in this case, the rule of law is secured by a strong public interest that laws enacted by their representatives are not imperiled by executive fiat. So that is the public interest. The balance of equities may in certain cases tip in the government's favor, but the government cannot reasonably assert that it is harmed in any legally cognizable sense by being enjoined from constitutional violations. There's no legitimate interest in enforcing the executive order that is likely unconstitutional and beyond its authority. Defendants in their briefing contend that because the challenged executive order is an integral part of the administration's broader effort to repair the immigration system, the preliminary injunction in no way prevents the executive branch from addressing unlawful immigration and does not infringe on the executive branch's power to ensure that the laws are faithfully executed. The preliminary injunction here merely prevents the executive branch from denying citizenship to individuals who are likely constitutionally entitled to citizenship. Remember, this is a preliminary injunction. And so the question is likeliness, not actual happening. And so the executive branch does not have a legitimate interest in violating the Constitution. The injunctive relief must be narrowly tailored to the remedy, the specific harm alleged, and an overbroad injunction is an abuse of discretion. As the Supreme Court recently held, courts lack authority to issue universal injunctions. However, equitable tradition has long embraced that the rule that courts generally may administer complete relief between the parties. The Supreme Court acknowledged that complete relief inquiry is more complicated for state respondents, and a universal injunction may be necessary to provide states themselves with complete relief. So it's not about individuals, it's about the state plaintiffs. The Supreme Court also declined to take up that argument, leaving it to lower courts to determine whether a narrower injunction is appropriate. The district court concluded that universal preliminary injunction is necessary to provide states with complete relief, as opposed to individuals, which was the Trump v. Casa case. We concluded the district court did not abuse its discretion. The states would need to overhaul all of their procedures to comply with the different laws and suffer irreparable harm under geographically limited injunction as they would without an injunction. So the government of the states are going to be harmed in this case, and that is the crux of the case. And the court concludes, we reject the approach. At the very end, the court says, the defendant's proposed interpretation of the Citizenship Clause relies on a network of inferences that are unmoored from the accepted legal principles of 1868. We reject this approach because it is contrary to the express language of the Citizenship Clause and reasoning of Wong Kim Ark. Executive branch practice for the past 125 years, legislative history to the extent that should be considered, and because it is contrary to justice. So that is the ruling, and I think that the appellate court addresses everything that it needs to address in terms of the procedural jurisdiction. It even gives up, dismisses the individual plaintiffs and makes this case only about states. So remember, the Trump v. Casa case is about individual injunctions in the birthright citizenship case. And the court said that individual cases cannot be blown up into nationwide injunctions by district courts. They did not say anything about states. So this case, Washington et al. Versus Trump, is about states getting complete relief and challenging the constitutionality of the executive order because of that. And with the case in New Hampshire, it is about individuals getting relief based on class certification. So in this case, they dismissed the plaintiffs because their claims are alive in the New Hampshire court because they fall within the putative class of plaintiffs who are about to give birth and their children are at issue, that their children's citizenship are at issue. So with that said, I think it's very interesting that conservatives care so much about the child before birth, but citizenship they want to restrict at birth. So you can regulate the woman's body that has the child in it before the birth in order to control the fate of the child, but then you don't grant it citizenship. That's their logic, and that is wholly inconsistent with anything from common sense to public policy. With that said, I end this extremely long episode. I hope I've given you some understanding of what the Citizenship Clause says, and we'll see what happens with the Supreme Court. This case is going up for appeal. And then we'll talk about the oral arguments of the Supreme Court and then the Supreme Court's decision. I see it being very difficult for the Supreme Court to not address the merits of the case and the novel assertion by the court of the states getting complete relief. And if that were a procedural issue, that's what this court, the Ninth Circuit, adjudicates here and says, and goes into the merits of it, saying that if you look at the law, and if you look at the laws governing the states, if you take away the Citizenship Clause and the Immigration and Nationality Act, then the whole thing unravels, and there's no way of telling who is a citizen, who is not, as it is directed in the 14th Amendment Citizenship Clause. Okay? So thank you very much. Talk to you soon.